Yes.
So, my lords, my lady, if I could remind you what I've got to in my argument. My argument is that the learned judge was wrong to suggest that the sensitivity principle should be qualified or caveated so that a claimant in a nuisance claim can rely upon a sensitive business if it is carried out at a sensitive, at a suitable location. I had 5 points for saying that. You remember my third point was that the learned judges suggested qualification of the sensitivity principle so as to extend the protection of nuisance to a claimant's sensitive business, undermines how nuisance upholds the rights of owners of land. And my fourth point is that that is illustrated in this case. And so in respect of the finding that my clients were liable in nuisance in respect of the digger's bucket being stuck in the air, I made the submission that if that's correct, it would mean that to an extent that would be uncertain even to an expert on falcons with a good understanding of the third respondent's business, it would mean that the second appellant would be prevented from putting all kinds of things in the air. And we looked at Martin Nicholas's evidence, so that would include flying a kite, using a crane, the sight of fireworks, and I got to the point of pointing out that it would also suggest that there would be a risk of liability if you flew a flag on the land, or erected a lamppost, or installed a CCTV camera on a pole, or erected a wind turbine on the land, or dried clothes on a washing line, or maybe if you repeatedly kicked a football into the air. Turning to noise, again, to an extent that would be uncertain even if you were an expert on falcons with a good understanding of the third respondent's business, the second appellant would risk liability by doing all kinds of things on its land that created a noise. So if we could look at what succeeded in respect of noise, if we could look at page 83 of the core bundle.
Yes.
So the first allegation of noise is in respect to the scaffolding business, and that's at paragraph 41, subparagraph 1. And the second category of allegations of noise related to noise arising from the construction of the barn, and that's at paragraph 41, subparagraphs 4 and 6 to 8. And looking at the judgment, page 158, the findings from the judgment about the noise created by the scaffolding business, page 158, I'd invite you to read paragraphs 365 and 368.
Yes.
The findings in respect to the barn, you'll see at page 161, as paragraphs 378 and 382 and 383.
Yes.
So if the learned judge was correct in holding that there was a noise nuisance due to the impact of the noise from the scaffolding business and the building of a barn on the sensitive falcon business, all kinds of other normal activities would risk being unlawful. For example, cutting grass. Trimming hedges, felling a tree with a chainsaw, setting off a bird scarer, and the use of noisy agricultural vehicles and machinery. Also, to an extent that would be uncertain even to an expert on falcons that knew how the third respondent ran its business, the second appellant would run the risk of being held liable for activities that might produce fungus. So there wasn't a finding of liability in respect of fungus, but the respondents made quite a big deal of it in the evidence. So if you turn to the supplemental bundle to page 6,
Yes.
this is from the first witness statement of Scott Nicholas, page 6, paragraph 10. The last sentence, Martin also explained, as explained to Mr. Thomas, that aspergillosis was one of the main problems for the falcons, and it was caused by a fungus present in the hay bales and manure, and could also be brought on by stress. And then at page 8, paragraph 20, he says that following Mr. Thomas's second planning application, a council meeting was held at which he objected because he was proposing to keep animals inside and outside the barn, which was adjacent to my property and my business. I also objected because the size increase was to account for a greenhouse and cattle shed, which would mean there was the potential for compost and manure to be stored next to the aviaries. Having rotting material next to the aviaries would have been dangerous for the birds. And then finally at page 30, page 53 of Martin Nicholas's first witness statement, paragraph 53, he says that I also told Mr. Thomas aspergillosis was one of the main problems with the birds. Now, I went on to tell him about a breeder in Germany whose birds were killed when a mushroom farm was set up next to the aviaries. So if the judge is correct, the second appellant would risk liability if it did things like grow mushrooms on its land, store compost, store manure, store other rotting material, keep bales of hay, or use hay for animal bedding. So if the judge is correct, there's a complete asymmetry in the positions of the second appellant and the third respondent as neighbouring landowners. The second appellant is prohibited, or might be prohibited, from putting its land to all kinds of normal uses, growing mushrooms, storing compost, storing manure, cutting grass, trimming hedges, felling a tree, setting off a bird scarer, flying a flag, erecting a lamppost, all of these things. But the third respondent is not prohibited from doing any of these things. Or any of the other things that are part of the ordinary use of land. The third respondent is asking in this case for unequal treatment from the law, seeking to impose restrictions on the second appellant's use of its land that it would not be willing to accept itself. My fifth point, final point, is that as we read the skeleton argument of the respondents, they make no attempt to justify the qualification that the learned judge applied to the sensitivity principle. Instead, they want to suggest that he applied the correct test for ascertaining whether there was a nuisance, namely whether there was a substantial interference with the utility and amenity value of the land. But that's an impossible submission. I've got 3 sub-points for saying that. First point is a point I made to Lady Justice Whipple this morning, which is the fact that the bucket of a digger is left in the air would obviously have no impact at all on the amenity of the neighbouring land. The second point, it was never part of the third respondent's case that the noise, whether from the scaffolding business or the barn or the digger's bucket being put in the air, it was never part of their case that substantially interfered with the utility and amenity value of the third respondent's land. So we've seen the particulars of claim. If we look at the respondent's skeleton, that's in the supplemental bundle at page 258.
This is the skeleton below, yeah?
Skeleton below, sorry, good point. Skeleton below, trial skeleton, 258, paragraph 20, the third claimant complains, under the heading nuisance, third claimant complains of private nuisance in the form of excessive noise and visual disturbances caused by the defendants to its falcons housed in the aviary. So in particular, there was no complaint about the interferences, the activities causing any interference to any other use of the third respondent's land. Remembering in Robinson and Kilvert, the judges noted that it had not been shown that heat from the cellar had interfered with the comfort of the plaintiff's employees, the paper merchant's employees. Look, there was no allegation that the activities would cause any substantial interference with any other potential use of the third respondent's land. Recalling that in the Hollywood Silver Fox Farm case, it was argued that the gunshots had harmed the fox farm only because it was a sensitive business, given that the gunshots would not have alarmed sheep or cattle, which are usually to be found on Kentish farms. And it is not alleged that the activities substantially interfered with the use of any other land. It was not, for instance, alleged that anyone occupying any of the neighbouring houses was disturbed by the activities. And my third sub-point on this is that the third respondent did not allege there was any nuisance outside the falcon's breeding season, as I understand it. And that tells you that absent the falcon business, there was no nuisance. So entirely consistently with the way in which the third respondent advanced its case, the learned judge did not hold that the digger's bucket and the noise had substantially interfered with the utility and the amenity value of the third respondent's land. And his finding of nuisance was entirely based on the impact on the falcon business, and we can see that at page 163, at paragraph 395 of the judgment. Where he says that even though malice has not been established, the proven acts of nuisance are, in my judgment, actionable because they were undertaken without proper consideration of the sensitivity of the third respondent's birds during the breeding season. So absent any even alleged allegation that there was a substantial interference with the utility and amenity value of the third respondent's land, and in consequence, absent any finding to that effect, the learned judge should have dismissed the nuisance claim.
Yes.
But even if the judge had held that the threshold test for nuisance was breached and the noise in the digger's bucket had substantially interfered with the utility and amenity value of the third respondent's land, he should nevertheless have held that the appellants had a defence to a nuisance claim because they were making a common and ordinary use of the land and were doing so conveniently. And to see what the judge said about that, if we could.
Yes.
First turn to page 158. Paragraph 364, there's an unreasoned finding that the scaffolding business was not making a common or ordinary use of land. That's in the second sentence. And in respect to the barn, the judgment deals with this at page 161 as paragraphs 382 to 383, and I'd invite you to read those paragraphs.
Sorry, which paragraphs?
It's paragraph 382 to 383. In this respect, there were two errors of law. The first error of law is the learned judge was wrong to hold that for the purposes of establishing whether a common or ordinary use of land has been conveniently done for the purposes of a defence to nuisance, the judge was wrong to hold that the defendant must establish that he has accommodated a sensitive business on the claimant's land. I've got three reasons for saying that.
Yes.
The first reason, it's never been held or suggested that that is the case, as far as we know.
Yes.
Secondly, that's inconsistent with the leading case of Andrea and Selfridge, which you'll find at divider 13 of the bundle. So the plaintiff ran a hotel and Selfridge's was carrying out building work on neighbouring land involving demolition and the erection of a new building. The demolition work caused a lot of dust and grit to be thrown up into the air, and there was a use of pneumatic hammers. And the Court of Appeal held that building works were common or ordinary use of land, but in this case they hadn't been carried out conveniently, i.e. with reasonable consideration of the neighbours. And if I could take you first to page 190.
Yes.
From the middle of the page onwards, there's a description of the hotel business. Actually, if you could read that, please. From halfway down onwards, from I should have thought of common knowledge. So the judges, this is the Court of Appeal, the Master of the Rolls, he's saying that the hotel is a particularly sensitive business. But if you look at what the duty is, it is to take all reasonable precautions not to cause annoyance to its neighbours. Page 192, just over 2/3 down, he says, I desire here to make one or two general observations on this class of case. Those who say that their interference with the comfort of their neighbours is justified because their operations are normal and usual and conducted with proper care and skill under a specific duty if they wish to make good that defence, to use that reasonable and proper care and skill.
Sorry, lost you. What was that?
So it's 192, 2/3 of the way down, paragraph starting, I desire. Then halfway down that passage, it's not a correct attitude to say we will go on and do what we like until someone complains.
Sorry, hold on. Where's it?
Page 192,
yes.
I desire.
Yes.
The point I'm making again, he's not talking about any duty to the particularly sensitive hotel. As you see 5 lines out, that is not a duty to their neighbours. And then it says their duty is to take proper precautions and to see that the nuisance is reduced to a minimum. There's another similar, page 194, 3/4 of the way down. I would say that in the case of this kind, where the defendant company has at a certain stage in certain respects, showed in my regard a reprehensible lack of regard for the duty it owes to its neighbours. I should not be disposed in drawing inferences to draw inferences with regard to loss of custom in the defendant's company's favour. So the Court of Appeal, in this case, the leading case, is saying that to take advantage of the defence, you need to be carrying out a common and ordinary use of land in a way that is reasonable in respect of neighbours. It's a single duty. It's not a series of separate duties owed to different neighbours depending on their sensitivity. Justices Gordon, Endelman in the Hunt Leather case agree with us, and I'll just give you the reference. It's page 1126 of the Bundle of Authorities.
Sorry, 1026.
1126.
Yep.
And my third point on this is a matter of principle. If nuisance as a property tort aims to protect land rather than any particular uses of land, the principles at every stage should be directed at the impact on the utility and amenity value of the land, not businesses, not sensitive businesses. The second error of law in this regard is the learned judge was wrong to hold that a scaffolding business was not a common and ordinary use of land. That was a holding unsupported by reasoning. Given that this court is in as good a position as the judge to ascertain whether a scaffolding business in that locality is a common and ordinary use of land, the court should be prepared to revisit that unreasoned finding if it considers that the judge got it wrong. And there's no dispute about the relevant facts. And in that regard, Lord Legate in Fern felt no difficulty in deciding that the viewing gallery at the Tate was not a common or ordinary use of land, absent any holding either way by the trial judge. And the reference there is paragraph 50 of Fern, page 961, 962 of the authorities bundle.
Same question again that I posed before. Is that inside your grounds of appeal, the challenge?
It is slightly compressed. There is a ground of appeal. It is there, but it is jumbled up with another ground of appeal. So page 16 or 15, it's ground 3. Towards the end of that ground, the learned judge was wrong to hold that the appellants were required to desist from carrying out building works and permitting the scaffolding business to operate from the land for a 5-month period.
That's okay. That goes to a slightly different point on its face, doesn't it? That's not. I gathered your submission.
Oh, that's right. Sorry. The ground 3 is that the learned judge was wrong to hold that for the purposes of the immunity from nuisance for the common and ordinary use of land, if reasonable steps are taken, such reasonable steps can be affected by the fact that the neighbour is carrying on a sensitive trade. And the point I'm making, I refer there not only to the building works to the barn, but also to the scaffolding business. So it's implicit in that ground of appeal that we are saying that the scaffolding business should have been categorised as a common and ordinary use of land. And I don't.
That might have been said a bit more.
It certainly we can be criticised for not saying that more clearly, but it was understood loud and clear by the respondents. I can probably just give you the notes. It's paragraphs 62 to 63 of the appeal skeleton.
Yeah.
Oh yeah, I mean that's referring back to what we'd said in our skeleton. So core bundle page 64.
Well, that's where the respondents say it's not open to you to take these points.
No, it says not open to us, not because it wasn't ground of appeal, but because we're bound by the finding at first instance.
I'd read that as being it, and you haven't appealed that, but maybe I'll be assisted a bit later. But I struggle to see your challenge to those fact findings, I confess, in the grounds of appeal.
This is our most difficult. The characterisation of the scaffolding business as a common and ordinary use of land is the most difficult part of our appeal. I just make these points about it. First of all, as we've seen from Andrea and Selfridge at page 192, another way of describing a common and ordinary use of land is a normal and usual use of land. And I'll just refer you to what was said on our side at the trial. It's at page 281 of the supplemental bundle. It's paragraph 37B. That's in the trial bundle, the trial skeleton on our side.
Whose skeleton is that?
This is from our side's trial skeleton. So I don't think I can improve on that. I'm keen to get on to negligence, given that whether we're right on this particular ground appeal, we should in any event succeed.
Yes.
So if I could now address you on negligence. Reflecting the third respondent's case, the duty of care that was found to exist was exceptionally widely framed. So the allegation in the particulars of claim is at page 206. Paragraph 22A. You see, it says that it's alleged the defence owed to the third defendant a duty of care not to cause or permit the falcons to suffer excessive noise or visual threats, in particular during the breeding season. That was the part of the particulars of the claim I was trying to find when in response to a question from Lord Justice Moylan. And at page 106, we find the finding in the judgment about the duty of care. Or at least the start of the relevant findings.
You say page?
Page 106 of the core bundle.
Yep.
So under duty of care, it starts by saying it might be said to be legally incoherent to advance a claim which could be summarised as you're under a duty of care to your neighbour not to commit a nuisance to him. And then 132, it says counsel's skeleton arguments address the legal principles governing negligence at only a very elementary level. And 134, he says Donoghue and Stevenson, of course, had nothing to do with litigation between neighbours and established the neighbour principle for the purpose of categorising the relationship between the manufacturer of the ginger beer and the person who drank it. In a case like the present, where the parties are actual neighbours in physical proximity, where the alleged breaches of the duty of care are claimed to be grounds of actionable nuisance, and where the recoverability of damages in nuisance is also subject to considerations of remoteness of loss, there may be no further legal space for the principle. So that seems to be the learned judge's initial inclination. But he ends up persuading himself, this is at page 112, paragraph 161, he said, I consider my conclusion for the purpose of this case that a negligence claim may be triggered not just by a failure to undertake competently what is otherwise lawful activity on land, but also by the timing of such activity to be an incremental development of the law of negligence. And then at page 164, it's a paragraph 397, the final sentence, or penultimate sentence in paragraph 397. It says, adopting an analogy-based approach in Robinson, a duty of care not to create disturbances that would harm the falcons during the breeding season should be recognised. So very, very wide. A duty of care not to harm the falcons during the breeding season. I have 7 reasons for saying that the learned judge was wrong to hold that the second appellant owed the third respondent a duty of care not to create disturbances that would harm the falcons during the breeding season. The first reason is that whilst there is often a duty of care not to damage or destroy another's property...
Sorry, can you start that again?
First point is that whilst there is often a duty of care not to damage or destroy another's property, whether chattels or land, that is not always the case. So if I could take you to Divider 41 of the bundle of authorities, the Robinson case. So, as you know, along with Michael, the Michael case, or Michael's case, this is a retreat by the courts from the idea that whether there's a duty of care can be judged by a single test. The current approach is at page, in Lord Reed's judgment at page 863, paragraph 29.
Sorry, paragraph number again?
It's paragraph 29.
Thank you so much.
Yes.
But I'd like to take you to Lord Mance's judgment at page 882.
Yes.
Lord Mance refers to the Marg Rich case, claimed by cargo owners against a classification society by whose negligence the carrying vessel was allowed to continue on her voyage after temporary repairs to a crack in her hull, which caused loss to both the vessel and cargo. The cargo owner's primary submission was that this being a case of physical damage to the property in which the plaintiff had a proprietary or possessory interest, the only requirement was a proof of reasonable foreseeability. The House rejected this categorically. And then over the page, after that passage from the judgment, Lord Mance says, whilst both the House and Lord Justice Savile in the Court of Appeal were happy to accept in most cases of the direct infliction of physical loss or injury through carelessness, liability was self-evident, that they were cautious to warn against absolute rules in that respect.
Yes.
My second point is that the courts have repeatedly cautioned against recognising a duty of care in relation to matters dealt with by the bespoke law dealing with the exercise and protection of rights of landowners.
Yes.
So if I could take you to the divider 25, Home Office and Dorset Yacht Company.
Yes.
So this is a 1970 case. So as you know, in the 1960s and 70s, the court's view of the scope of the law of negligence was at its most expansive, and building on Lord Atkin's neighbour principle, the courts were attempting to articulate or build on the attempt to articulate a single test for whether there was a duty of care. Duties of care were being found in all kinds of new situations. At page 387, we go to Lord Reed's speech. And I'd ask you to read at the very foot of the page, there's a paragraph starting in later years. And I'd ask you to read that paragraph. It goes on over the
Remind me of the page again.
387.
Thank you. Yes.
So lots of interest there. I mean, he starts off by saying that when this is bottom of page 387, when a new point emerges, one should ask not whether it's covered by authority, but whether recognised principles apply to it. So completely different to the current approach in Robinson. About 5 lines down, he says, I think the time has come when we can and should say that there should be a duty of care for foreseeable loss unless there's some justification or valid explanation for its exclusion. That was adopted by Lord Wilberforce in the Ann's decision. And then when he gives examples of justification for excluding the imposition of duty of care, one of the examples is the long chapter of the law determining in what circumstances owners of land can and in what circumstances they may not use their proprietary rights so as to injure their neighbours. Also, he then says, but where negligence is involved, he doesn't seem to think the normal use of land, even in a way that can harm a neighbour, would count as negligence. Now, where does that expression, a long chapter in the law, come from? It actually comes from Donahue and Stevenson. I needn't take you to it, or perhaps I... Perhaps I can. It's divider 10. It's page 138. So this is Lord Macmillan, who's part of the majority in Donoghue and Stevenson, and he's at page 138 trying to go through the English authorities and to see if there's anything in them which suggests there shouldn't be a duty of care owed by the manufacturer of the ginger beer to the consumer. And you'll see in the second paragraph on that page, I observe in
Sorry, let me get behind.
page 138.
Thank you.
So when Lord Macmillan goes through the authorities, the English authorities, the first two cases he refers to are Cavalier and Pope and Cameron and Young. And they're property law cases, they're landlord and tenant cases. But he puts them on one side because he says they're in a different chapter of the law. So that's where that expression in Lord Reed's judgment in Dorset Yacht Company comes from. Obviously, Donoghue and Stevenson being a Scottish case in relation to my learned friend's complaint that we're relying on a Scottish case in which it was held that the law in that regard in respect of English and Scottish law is the same. Divider 26 rather, there's a Court of Appeal decision, Smith and Scott.
Yes.
A council housed a problem family in a council house knowing they were likely to cause trouble to neighbours. And they did, and the neighbours sued the local authority complaining that they would be negligent by housing them there. At page 438, which is in the judgment of the trial judge, the Vice-Chancellor, at C, he says, the Scots have a large and unruly family. I'm satisfied beyond doubt. Indeed, it's not challenged that the conduct of the Scott family as a whole was altogether intolerable, both in respect of physical damage and of noise. So this was a physical damage case. But the judge held there was no duty of care, and that's at page 441. And it's point 3 on page 441. He refers to Lord Reed's mentioning reference to property cases in the Dorset Yacht Company case. And at the end of that paragraph, he said, I should add that the relationship of landowner, tenant and neighbour is in its nature of the most widespread possible occurrence. And the introduction of the duty of care in this connection would have far-reaching implications in relation to business as well as to residential premises. So my third point is that it is therefore no surprise that there are authorities in which a landowner has foreseeably damaged or destroyed chattels on a neighbour's land or even damaged the neighbour's land itself, where there was no liability because there was no duty of care. Negligence wasn't argued, but Robinson and Kilvert is such a case. The relief sought was an injunction to stop the heat going through the floor to the paper merchant's premises. So, given that the defendant knew it was causing a problem, it was an injunction against foreseeably causing property damage to a neighbour, but the defendant was held not liable, albeit negligence wasn't argued. The Hollywood Fox Farm case. So this was a case of foreseeable harm, foreseeable damage or destruction of chattels on a neighbour's land. But if you remember, it was the judge held that it was implicit in the judgment that absent malice, there would have been no liability. But if the judge was right in our case, malice was the wrong test. You'd have thought the test should have been negligence. Smith and Scott, which we've just looked at, was a case of the local authority doing something which foreseeably gave rise to a risk of property damage on a neighbour's land. I can just give you the reference, but Divider 24, Stevens and Anglian Water Company, it's in the context of law relating specifically to water, but that is also a case of where it was held there was no duty of care, despite the fact that the water company had extracted water, which foreseeably led to the destruction or damage to a neighbour's property.
Yes.
My fourth point is of the various established categories in which a duty of care is owed, there is not a category of neighbouring landowners in respect of normal but competing uses of land. So a duty of care is owed by a manufacturer to a consumer, by a doctor to a patient, by a lawyer to a client, by a driver to a pedestrian, by an employer to an employee, by a property owner to a visitor. But there isn't an established category of negligence in the case of landowner and neighbour, simply in relation to normal but competing land uses. My fifth point of the 7 is that whilst there are cases in which landowners have been held liable for activities on their land which have damaged a neighbour's property or chattels, the gist of such claims is that the activity has been carried out carelessly so as to cause unintended damage. It tend to be accident cases. There's carelessness, accident, unintended damages. And in that regard, if I could take you first to Divider 14 of the bundle, to the Sedley-Denfield case. So this is one of the cases in which the liability for negligence has been expanded to include not only interference with a neighbour's land caused by the defendant, but also for not taking reasonable steps to deal with issues relating either to something caused by a trespasser or to a natural hazard. At the top of page 220 in Lord Wright's speech,
Yes.
he says, second line, but the gist of the present action is the unreasonable and unjustified interference by the defendant in the user of his land with the plaintiff's right to enjoy his property. Negligence, moreover, is not a necessary condition for the claim in nuisance. What is done may be done deliberately and in good faith and in a genuine belief that it's justified. Negligence here is not an independent cause of action, but is ancillary to the actual cause of action, which is nuisance. So it was held there was liability both in nuisance and negligence. But I'm referring to this because of the reference to the importance of thinking about what the gist of the complaint is. And there's a similar reference to the gist of the complaint at divider 18. So this is Bolton and Stone. During a game of cricket, the ball was struck out the ground and it hit an owner of property on the highway outside her house. And the question is whether the cricket club were liable in negligence. The House of Lords ultimately thought not. And if I could refer you to Lord Radcliffe's speech at page 282, at the foot of the page, he says this, he says, those being the facts, a breach of duty has taken place if they show the appellants guilty of a failure to take reasonable care to prevent the accident. One may phrase it as reasonable care or ordinary care or proper care. All these phrases are to be found in decisions of authority, but the fact remains that unless there's been something which a reasonable man would blame as falling beneath the standard of conduct that he would set for himself and require of his neighbour, there's been no breach of a legal duty. And in this case, they thought the cricket club wasn't to blame because although the injury was foreseeable, it was really so unlikely it was to have such a thing would happen so infrequently. There was no liability in negligence. So where a landowner has been held liable in negligence to a neighbour as a result of doing something on its land that has damaged the neighbour's land or destroyed or damaged a chattel on the neighbour's land, the gist of the complaint is that the landowners, in the course of an otherwise lawful use of his land, as I've said, acted carelessly or, colloquially speaking, negligently to cause some unintended harm. There's been a lack of skill and care. So the cricket cases are an example of playing, the allegation is playing, it was a playing sport carelessly. And the fact that the claimant may have been an owner of neighbouring land was for the purposes of the negligence claim really incidental. Equally, I needn't take you to it, but at Divider 39, there's a case called Northumbrian Water and Sir Robert McAlpine. And in that case, it was argued that a contractor, building contractor, was liable in negligence for having allowed concrete to escape from a building site that damaged a water authority's sewer. It was, in fact, held to have been no negligence, but you know, that was a case relating to the uses of neighbouring land. But the gist of the complaint, so far as negligence was concerned, it was carelessly carried out building works. Carrying out building works carelessly. And the fact that the victim in that case happened to be situated on neighbouring land was, for the purposes of a negligence claim, incidental. So, for the purposes of the negligence action, what is the gist of the complaint in this case? Why are my clients said to be to blame? They are not said to be to blame in the way in which someone liable in negligence might be said to be blamed. They have not acted carelessly in any obvious sense. They've not failed to exercise any skill or care. Colloquially speaking, they have not been negligent. They would be liable in negligence if, when building the barn, they had carelessly allowed a fire to start, which had spread to the aviary and burnt it down. They would be liable in negligence if, when felling a tree, they had done so carelessly and allowed it to fall over onto the aviaries, causing damage to the aviaries. They would be liable in negligence if, having offered to feed the falcons, they had left the door open so some falcons escaped. The gist of the complaint in negligence, instead, essentially, is that my clients are said to be to blame because of the priority they accorded to competing neighbouring land uses. My clients are said to be to blame because they should have refrained from using their land in perfectly normal ways for much of the year in order to accommodate and protect a competing land use, a competing sensitive neighbouring land use. But that exercise of according priority to competing neighbouring land uses is undertaken by the law of nuisance. the law of nuisance tells us that pursuant to the way in which it upholds and protects the rights of the owners of neighbouring land, a landowner cannot complain about interferences with a sensitive use of land that would not have substantially interfered with the utility and amenity value of its land. The first instincts of the judge in this case were correct. Given the stance adopted by the law of nuisance, there is, using the words of the judge, no further legal space for the law of negligence. My sixth point is that saying that a landowner owes a duty of care not to harm a sensitive business on neighbouring land, even in respect of a business which is located at a suitable location, would cause all kinds of problems. At a very at the highest level of generality, if I could take you to Divider 59 of the bundle of authorities, this is a speech given by James Endelman, now Justice Endelman of the High Court of Australia, who we saw appearing in the Hunt Leathers case. It's an interesting speech about Donoghue and Stevenson and how Lord Atkin got everything wrong in that. But I want to refer you to page 1322. He's referred to the fact that in Donoghue and Stevenson, liability was based on the fault of the defendant. And he then says our law of torts became bifurcated. Some torts focus on particular rights of a plaintiff, which have been infringed, including the property torts. Other torts, more particularly negligence, focus on the fault of the defendant. In the latter group, there are then many difficult value judgments required to determine the boundaries of such liability for fault, particularly in the case where economic loss is caused. And then he says in the next paragraph that in seeking to impose on law of torts a general model of fault, as we've seen in French law, Lord Atkin undoubtedly failed, we still have many, many torts in our law which are based on strict liability protection of rights, and that includes trespass to land. And then in the next passage, he says, as many rights have observed, this bifurcating nature of the law of torts has created difficulty in the cross-cutting or overlapping with torts which allow for liability based on infringements of particular rights.
Yes.
So at a high level, you might expect issues of lack of coherence if you're trying to mix up a property strict liability tort with a tort based on culpability. And indeed, the law would be incoherent if a landowner, as the judge thought, owes a duty of care not to harm a sensitive business on neighbouring land. It would mean that the sensitivity principle would apply, presumably, unless the loss was of a type recoverable in a negligence claim. And that would just punch holes in the sensitivity principle in a way that would be arbitrary. And a point I mentioned to Lady Justice Whipple, I think this morning, nuisance has no difficulty, the hard-edged principles of nuisance have no difficulty dealing with the question about what a sensitive business might be expected to do, thinking about the falcon business closing up its windows. But without the hard-edged principles of nuisance, the law of negligence would find it hard to explain the scope of a landowner's duty to avoid interference with a neighbour's sensitive business in circumstances in which the sensitive business could do something about the interference. And just practically speaking, as we point out in the skeleton argument, the judge's judgment, if correct, is seriously bad news for developers, the hospitality industry, and the economy more generally. If you have a developer or contractor carrying out piling work at a development site in central London, faced with a block of flats and a row of commercial properties, the law as it is stood for since the late 19th century it is clear. There's basically the developer owns the same duty to each of the flats or each of the commercial units. On the judge's approach, there would be an ever-changing kaleidoscope of duties depending on what they know about the sensitivities of the occupiers and their businesses. It suggests that a developer would have to investigate the sensitive business of a neighbour, perhaps having an inspection, getting an expert report, in order to understand what its duties were. My seventh and final point is that the absolutely fundamental problem with the judgment is it fails to uphold the second respondent's rights as an owner of land. That's the fundamental problem with it. And I'd like to take you to two cases in respect to that. The first one is the underpants case, Grant and Australian Knitting Mills at Divider 11. So this is the Privy Council quite soon after Donoghue and Stevenson. A plaintiff had purchased woolen underwear, I think a vest and long johns, and contracted dermatitis due to the excess sulfites in the wool. Plaintiff alleged that the manufacturers owed him a duty of care, and the Privy Council agreed, and the judgment was delivered by Lord Wright. page 170, 171,
Yes.
just as a historical footnote, interesting to see how they describe the ratio in Donoghue and Stevenson, at the bottom of page 70. No mention of the neighbour principle. But what I'm interested in is the third paragraph on page 171. The judge says it's clear that the decision treats negligence, whether as a duty to take care, as a specific tort in itself, and not simply as an element in some more complex relationship or in some specialised breach of duty, and still less as having any dependence on contract. All that is necessary as a step to establish the tort of actionable negligence is to define the precise relationship from which the duty to take care is to be deduced. It is, however, essential in English law that the duty should be established. The mere fact that a man is injured by another's act gives it in itself no cause of action. If the act is deliberate, the party injured will have no claim in law, even though the injury is intentional, so long as the other party is merely exercising a legal right. That's what's happening here, and it's well illustrated by the case at Divider 6 of the bundle, Scottish case of Armistead and Bowerman. So the pursuer, who was the tenant under a lease, farmed salmon at land in Dumfries. But to operate successfully, the fish farm required a supply of perfectly pure water. Water was provided to the fishery from a stream that flowed through a pine plantation. During a storm, a large part of the timber in the plantation was blown down, and the defender purchased the fallen timber. And using horses, the defender dragged the timber through the stream. The stream became fouled, and fry and fish in the hatchery were destroyed. And the trial judge found in favour of the pursuer in negligence. And we see that page 50. So halfway down the sort of main part of the page, it said that the Lord Ordinary pronounces interlocutor, and he says this, he finds that the defender has a right to remove the fallen timber in the said plantation, and it was his duty in doing so to take reasonable precautions against fouling the stream supplying the said hatchery. And he found that the defendant was negligent in the performance of that duty. Page 51. So we're now most of this page is in the footnotes. So this is from the judgment at first instance. The paragraph starting the next and only other question, 4 lines in, the trial judge said, if the defender is not a trespasser, he's only responsible, as it seems, for the observance of the law of the neighbourhood. Hence it is urged that the acts complained of do not give rise to an action unless they amount to a nuisance. It must be admitted that the fouling of a stream by dragging falling timber across it would not amount to a nuisance. But I cannot accept the defender's view that an injury done to a neighbour is not actionable unless it amounts to a nuisance. The obligation of the neighbourhood is expressed in the Latin principle that you must use your land so as not to injure a neighbour's land. The supply of pure water is essential to the pursuer's business. The pollution of the streams which feeds his hatcheries was calculated to destroy the whole produce of his undertaking for a year. Assuming, but only for the purposes of testing the argument, that it was known to the defender, I conceive that the obligation of the neighbourhood required the defender to use reasonable degree of care and trouble to avoid injurious pollution. There are 3 points for consideration with reference to the alleged injuries. Was the defender made aware of the injury which the temporary fouling of the water would cause to the hatcheries? Was it possible, by the use of reasonable and inexpensive expedients, to avoid the fouling of the water? Was the defender negligent in the performance of the duty of taking reasonable care to avoid fouling the water? And at page 52, we see what the trial judge thought the defender should have done. In the paragraph starting towards the top, on the Monday of the 30th of December, and going to about 5 lines from the foot of that paragraph, he ought either to have suspended the work during the thaw, because if it was iced over, it would have been no pollution of the river, or have laid down a bridge of logs over the watercourse for which materials lay ready to hand, or at the least he ought to have consulted the pursuer and given him an opportunity of making a log bridge or doing what was necessary to preserve the water from contamination. An appeal was allowed. The Court of Session allowed the appeal. The defender was held not liable in negligence because he was simply exercising his legal rights. So if we look at the judgment of Lord Justice Clark, with whose judgments the other 2 judges agreed, first of all, at the top of page 52, you'll see he starts his judgment by saying this is a case of some interest. And at page 54, the first full paragraph, he says, I own to feeling great regret for the loss, which has been considerable, and about 5 lines in, but I must fairly own that I am unable to follow the Lord Ordiner in his reasoning. It appears to me that the whole ground of action is false. I think that the defender incurred no liability in consequence of anything which he did. I think that he acted simply as he was entitled to act in the exercise of his ordinary rights, and that there was no ground of complaint whatever in any part of his proceedings. On the other hand, I think, although the proof, voluminous as it is very slender on the point, that if the pursuer had taken reasonable precautions, this injury would have been avoided. At the foot of the page, 4 lines up, the mode in which the defender cleared the forest of wood was by horsepower and dragging the trees along the ground using certain drag roads, which had been made on previous occasions by the forester, a very simple and, as far as the evidence goes, a perfectly legitimate mode. And perhaps you could read the next paragraph.
Yes.
So that is the correct legal analysis of facts that are very similar to our facts. So they're my 7 points. The last thing, we've got a ground of appeal that, one of our grounds of appeal is that if there was a duty of care, there was no breach of the duty. And I really just want to say this, that if there's any scope for any operation of any duty of care, it cannot possibly operate to prevent my clients doing so much on their land for such a long period of time. For 5 months of the year, and in all the respects I've identified, to restrict their normal uses of the land. And really that's all I want to say about that point. So unless there's anything further I can help you with, they're my submissions. I'd like to hand over to my learned junior, Miss Lamont.
Christopher, do you have any questions? No. Yes, thank you. Yes.
My lords and my lady, the majority decision of the Supreme Court of Canada in case of Grandel and Mason, case from 1953. Was relied upon by the third respondent below as being highly persuasive in support of the existence of parallel duty of care in negligence. And one can see that from the core bundle at page 107, at paragraph 138 of judgment. On page 107, that's paragraph 138.
Yes.
And that case played a central role in the submissions and consideration of this issue below. And it is clear that the judge placed great weight on the reasoning of the majority of the Supreme Court of Canada, albeit recognising that that authority was not binding on him, and that can be seen at paragraph 138 again. We say, our submission is that the learned judge was wrong to place any reliance on that decision in coming to his conclusions regarding the scope of the duty of care in negligence. At page 109 of the bundle, paragraph 147 of the judgment, if I could ask your lordships and ladyship to read that paragraph. Essentially, the learned judge there treated the decision in Grandel as being authority for the proposition that there can be a liability and negligence arising out of building works, which might also not be actionable in private nuisance. And also that a particular duty of care may arise through the defendant being put on prior notice by the claimant of the need to make adjustments to the works to accommodate the claimant's concerns. And likewise, in the judgment at paragraph 154, on page 110, the learned judge said that any such liability in negligence, including to a claimant whose operations are particularly sensitive to any such activity, would exist alongside and resting on carelessness would obviously be wider than the liability of a neighbour whose liability and nuisance is dependent upon him having acted maliciously and so as to cause harm, cross-referring there to the Hollywood Silver Fox case. Now, standing back, overall, Grandel is one of a trio of Canadian cases from the 1950s that are referred to in the bundle of authorities, and they can be conveniently found together at tabs 46, 47 and 48. They are all relied on in this case by the respondents, and they all concern damage to noise-sensitive female mink, which have resulted from works carried out on neighbouring land during the whelping season. Like the falcons in this case, mink are particularly sensitive to unwelcome, unusual noises in the vicinity of their pens during the whelping season, which the evidence in the cases seems to differ, but is anything from 2 weeks to just over a month. At a more general level, these cases can all be seen properly in our submission as a product of a particular time and place in which they were decided. Mink farming being an important and well-known enterprise in that part of the world at that time, and that is clearly referenced by Supreme Court Justice Esty, giving the majority judgment in Grandel, which is at page 149 of the bundle of authorities, and that's tab 47.
Said.
Tab 47 in
Yes.
the decision. It's perhaps not surprising in the circumstances that the common law in Canada has developed in a manner so as to protect such an important industry in that jurisdiction. But even at a more principled and granular level, there are particular features of the facts and reasoning in the Grandel decision that in our submission made it not only an imperfect comparator, for adopting a duty of care in this jurisdiction, but also an impermissible one. And I shall come on to look at the particular reasons, but in summary, Grandel was not a case concerning the respective rights and duties of neighbouring landowners as between each other at all. And secondly, but no less importantly, the analysis and approach of the majority in the Supreme Court of Canada in Grandel in respect of liability for damage to sensitive trades in the law of nuisance does not mirror the common law as it applies in this jurisdiction and as is most recently authoritatively set out in the Supreme Court's decision in Fern. Accordingly, in our submission, the judge should not have placed weight on its reasoning in holding that the appellants in this case were liable in negligence for the damage to the falcons on the basis that they were under a duty by reason merely of them having been put on prior notice of the need to refrain from carrying out works during the breeding season. The basic essential facts in Grandel are these. Mr. Mason, who was a mink farmer, had a farm adjacent to a public highway in which he raised mink. He had raised his concerns as to the impact of proposed highway works with the superintendent of the Department of Natural Resources within the provincial government. And as a result of expressing those concerns, had been sent a telegram informing him that the chief engineer of the highways department of that government would commence work further up the road, in other words, away from the mink, if possible. And that can be seen at page 145 of the Grandel case. In turn, the chief engineer had passed those instructions down to the construction foreman, Mr. Olson, who in turn informed the defendants. And the fact, their knowledge of those instructions can be seen at 1051. But halfway down, Justice Esty saying, there is much evidence to the effect that it was common knowledge that the gap left was to protect the plaintiff's mink.
Sorry, where
Halfway,
151, 51.
1051.
Yeah.
About halfway down, in the interval between the 5th and the 9th, the learned Chief Justice, that's the Justice of the Court of Appeal in that case, speaking on behalf of the Court of Appeal, observed there is much evidence to the effect that it was common knowledge that the gap was left to protect the mink. It's important to appreciate in our submission that the defendants in that case were not landowners or even the highway authority undertaking the roadworks that caused the damage to the mink. They were not occupiers and they were not in possession of that road. Rather, they were merely 5 employees of the highway authority, 2 sub-foremen and 3 vehicle operators, who had operated their noisy machinery in close proximity to the mink pens in breach of direct orders given by their superiors to avoid that area when they had known that the reason for the order was to avoid damaging the mink. It is informative in our view, in our submission, to consider the particular procedural history in that case, which is rather unusual. The claim was pleaded as one in nuisance alone, but it had also been treated as one in negligence by the courts below. The claim had been dismissed at first instance by Justice Taylor. And Justice Taylor had dismissed the claims on grounds that there had been, in his view, no evidence that the defendants did anything other than in pursuant to orders given to them. And that can be seen at page 1057. At the bottom there. And essentially what the learned judge was saying there was that he suspected there had been negligence in the supervision of the works, but there was no evidence against these individual defendants. But he also said the following, that where he had also made the point that where a fur farm with these female mink at times so susceptible to noise is located on a much travelled highway, the owner must, in so locating, do so at his peril, and his industry can claim no special privileges as of right, nor object to the noises incidental to the use, repair, reconstruction and maintenance of the highway by the highway authorities. It's clear that in the Court of Appeal, the judges took a very different view of the evidence, finding the particular defendants in that case culpable. And on a second appeal to the Supreme Court of Canada, the majority, by a majority of 3-2, the second appeal was dismissed, on holding that the defendants were liable in both nuisance and negligence for the resulting damage to the plaintiff's mink. And that can be seen at page 1043 in the head note itself, that the point 1 is dealing with the claim in nuisance, and point 3 is dealing with the decision in negligence. The judges dissenting in that case, Supreme Justice Locke and Taschereau, Locke giving the main judgment, their dissent was to the effect that the defendants as servants of the Crown could not be liable in nuisance to any greater extent than their employers, who could themselves not be held liable for simply carrying out highway works in the ordinary course in the ordinary way, and that is at 1063. One can see the dissent on the passage first highlighted at the top of that page. In my opinion, a person establishing an industry of any nature upon a public highway, which of necessity maintenance and construction works must be done from time to time in the ordinary course of events, has no right in law to complain of the noise attendant upon the performance of such work on the ground that it is a nuisance, and accordingly the claim advanced in the present matter must fail. Dealing specifically with the allegations of negligence, the dissenting view in the Supreme Court was that, given that there was no suggestion that the machinery had been operated in a negligent manner, so as to make more noise than that which would ordinarily result from its operation, that it was unfair in a sense there had been no specific allegations as to the particular involvement of any particular defendant. So essentially taking the same view as Justice Taylor had taken at first instance. In our submission, His Honour Judge Rooson's reading of the decision in Granzel was wrong, and he shouldn't have applied it in the way he did for 5 reasons. The first reason is that the 5 individual defendants in Granzel were held liable by the majority of the Supreme Court on the basis of the same facts in both nuisance and negligence, and notwithstanding the undoubted sensitivity of the mink in that case. Accordingly, the decision is not authority for the proposition that a landowner owes a duty of care to its neighbour that is wider than the duty it owes in the law of nuisance, so as to preclude it or otherwise inhibit it from using its own land for entirely legitimate purposes on account of its neighbour's sensitive trade. To use the heat-sensitive paper analogy, one cannot put a cigarette paper between the causes of action of that application by the Supreme Court in relation to nuisance and negligence on the facts below. Secondly, the judgment at paragraph 146 at page 108 of the full bundle this is the passage of the learned judge's reasoning below when he refers to the dicta in the majority decision in Granzel. And he refers to the fact there that at page 466, that the decision was quite apart from any question of nuisance. It would appear that the appellants are liable on the basis of their own negligence. And that is certainly one of the findings of the Supreme Court. But below that, the judge refers back to pages 463 to 464 of the majority decision, and referencing the particular paragraphs that are set out there below. But those were not passages in Grandel dealing with the liability in the law of negligence. They were passages dealing with liability in the law of nuisance. And that can be seen from Grandel itself at page 1047. Page 147, from where the red lining is, this is where the passage referred to starts. And this is, in a sense, where the judge is referring to the Robinson and Kilvert principle, an Eastern and South African Telegraph Company principle, because the objection was made in that case that there was no liability because the mink were a particularly sensitive business. And so it is in dealing with those submissions in this respect that Justice Esty said that this doesn't necessarily conclude the matter. He refers there to the fact that they were not only acting contrary to instructions, but were acting that reasonable men would have foreseen the damage. And what is illustrative there is the reasoning that follows right until the end of, to the middle of page 1049, to the red line section there. Because essentially what the majority are doing there is saying that the fact that the workmen had acted negligently in operating in a machinery in a prohibited area, because of that fact, they could not avail themselves of a defence to a claim of nuisance but by relying on the delicate and sensitive nature of Mr. Mason's mink business. Because such a defence would, in the Supreme Court's view, only avail a defendant who has acted with reasonable care. So the judge there is drawing an analogy with the requirements of the Andrea and Selfridge principle, that one cannot rely on that immunity unless one has acted with reasonable care, and likewise with the immunity by reason of statutory immunity. But in so doing, it is clear that the majority in the Supreme Court have fallen into error. Well, certainly that is not the law as it applies in this jurisdiction. At page 1046 of the authorities bundle, it's uncontroversial there that Justice Taylor had made a finding that was not challenged on appeal to the effect that the mink farm, particularly during the whelping season, was a delicate and sensitive business. And what is important there is Mr. Mason did not object to the noise, except insofar as it caused death to his mink, nor is it otherwise suggested the noise interfered with the comfort or convenience of the residents of that locality or adversely affected their property. And in our submission, on the basis of that finding, it must necessarily follow that the noise made by the defendant workmen in carrying out the roadworks near to the mink pens could not have amounted to an actual nuisance at all, absent malice, because it was not proven that the noise would have amounted to a substantial interference with the amenity of Mr. Mason's land by reference to its common and ordinary use. And in referencing or relying on seeking to draw an analogy from the defences in Andrea and Selfridge and in relation to statutory immunity, the Supreme Court fell into error because there was no need to defend an action, because the action should have been dismissed without more. There was no need for a defence. Put quite simply, the sensitivity principle does not operate by way of a defence. And the analogy with other types of immunity was in our submission wholly inapt. And it can be seen that the learned judge in this case fell into the same error at paragraph 150 of his judgment. In saying there at page 109 of the core bundle, the reasoning in Grandel supports the conclusion that the facts of a particular case may mean that the principle, so use your property as not to injure your neighbours, applies to the timing and manner of what would otherwise be the defendant's unobjectionable common and ordinary use of his land. Also, and significantly for present purposes, a duty of care arising out of such facts may overcome a defence to a nuisance claim that recovery should be denied because of the delicate and sensitive nature of the respondent's business. In other words, Grandel indicates that a claim in negligence could qualify the impact of the fourth proposition in the law of nuisance in paragraph 53 above, and that's the passages in Fern dealing with the sensitivity principle. And on that basis, the judge concludes that the law of negligence may operate to protect even sensitive uses of land during periods of heightened susceptibility. So there, the judge can quite clearly be seen to fall into error because that part of the judgment is clearly contrary to the Supreme Court decision in Fern and is demonstrably wrong. And further, the decision in Hollywood, Silver Fox Firm and Emmett that my learned Lena has already taken the court to is authority in this jurisdiction that a higher degree of culpability is required, in other words, malice, as the judge himself appears to recognise at paragraph 154 of his judgment at page 110 of the core bundle. He says, any such liability and negligence, including to a claimant whose operations are particularly sensitive to any such activity, would exist alongside and resting upon carelessness, would obviously be wider than the liability of the neighbour whose liability and nuisance is dependent upon him acting maliciously and so as to cause harm. Now there is an inherent contradiction there in analysis between paragraphs 150 and 154, and it is clear in our submission that the judge has fallen into the same error as the Supreme Court in the Canadian Supreme Court of essentially conflating the law of negligence and nuisance in this case. In our submission, the dissent of the two judges in the Canadian Supreme Court, the judgment given by Justice Locke, is the reasoning in those judgments is in our submission unassailable. And again, I have already taken the court to those passages from Locke. Basically, the reasoning being there that the highway authority would have no liability simply by reason of doing its highway works, even if it knew of the sensitivity of the mink and the potential impact of the works on that mink. It is entitled into the risk falls in those circumstances on the mink farmer and not on the highway authority. Our fourth point about why no weight should have been accorded to this decision is that it's a case in which the defendant's use of the land which caused damage to the mink was illegitimate as opposed to legitimate use of land. And standing back from it, it's clear that the reason why the defendant workmen were held liable in negligence individually, as they were, was because they had undertaken works in a prohibited area that they had been ordered by their supervisors to avoid, precisely for the purpose of not damaging the mink. And they also knew of the likely consequences to the mink of so doing. So in disobeying their orders in this way with full knowledge of the consequences, the conduct of the defendants was clearly blameworthy, culpable on the facts of that case. In a sense, they were in no different position than joyriders or other trespassers, causing a nuisance around the area of the mink pens for no good reason. They weren't exercising any legitimate land rights. They were creating havoc, essentially. The subsequent case of Rattray and Daniels, which is at page 1067 of the bundle, authorities bundle, tab 48. Clinton Ford, the Chief Justice of Appeals, delivering the judgment of the Alberta Supreme Court in that case, characterised the defendants' negligence in Grandel as being their failure to carry out the instructions of their superior officers to cease operations opposite the plaintiff's mink farm.
Where's that?
That's at page 167. 1067. It's at the bottom, my lord.
Right, yes.
And again, in Grandel itself, at page 1063 of the bundle, Justice Locke described the alleged negligence in that case in similar terms. Again, just at the top of where the second red line is on page 1063. The negligence suggested is that of having operated in that area at the time in question contrary to their instructions. And it is noteworthy that this decision, the Grandel decision, is its citation in the leading text of Clark and Lindsell is alongside Hollywood, Silver Fox Farm, and Christie and Davy. In other words, it is footnoted in the section dealing with intentional damage to land, and that can be seen at tab 52 of the authorities bundle.
Sorry, which page?
It's page 210 is the text. 1210.
Yep.
It's there at 1916. Acts done with the intention of annoying a neighbour and actually causing annoyance will be a nuisance, although the same amount of annoyance would not be a nuisance if done in the ordinary and reasonable use of the property. And the citation is 117, footnote 117, which itself appears at page 1215.
Yes.
Our final point in relation to Grandel is that no consideration at all was given by the majority in Grandel to the question of whether the Highway Authority itself would have breached a duty of care and negligence had it pressed ahead with its works, notwithstanding the fact that Mr. Mason had raised his concerns with them regarding the impact of the work on his mink. The Highway Authority were not party to the proceedings, and Grandel is not authority for the proposition that they owed Mr. Mason a duty of care to work around his mink operation. So viewed thus, the case didn't even address the conflict between competing land rights and uses, which in our submission is at the heart of the law of nuisance. Grandel was not a case which turned on the rights and duties as between owners or occupiers of adjoining land in the way that this case does. Yet it formed the central plank of the third respondent's case as to why the appellant should bear responsibility for damage caused to the falcons from building works and other activities on our client's land that were otherwise entirely unobjectionable. So therefore, in our submission, far from being highly persuasive, Grandel did not support the wider proposition for which it was cited, and the judge should not have placed any weight on it, let alone the significant weight that he did. There are two other cases that are cited referred to in the bundle that inserted by the respondents in this case. I can deal with those very shortly. The first is McGibbon and Robinson, and that is at tab 46. On page 1037.
Yes.
Essentially, I'll make three very quick points about this case. It's a decision of the Court of Appeal of British Columbia Court. Date was decided also in 1953, very shortly after Grandel. In fact, the first instance decision had been cited in Grandel itself. The Court of Appeal decision in McGibbon and Robinson refers to the unreported case of Grandel in the Supreme Court. But what is noteworthy about that case is that there's no real consideration given as to the distinction between nuisance and negligence at all. I mean, it's not surprising in light of the Grandel decision that the principles applicable in nuisance and negligence were conflated in this way. And again, for the same reasons, it does not support the existence of a duty in negligence that is wider than that owed in nuisance. One can see, for example, on page 1038, Justice O'Halloran at the top refers to the case being concerning Donahue and Stevenson, whereas Robertson, Justice of Appeal, puts the question rather differently. The question arising in this appeal is whether or not the defendant was making reasonable, natural and not excessive use of his land under the following circumstances, which is, of course, the language of nuisance and not negligence. Although Robinson and Kilbert and Eastern and South African Telegraph are cited in that case on page 1039, they are mentioned there for the proposition that the plaintiff cannot, by engaging in some particular trade on adjoining land, prevent the defendant from using his land reasonably. In our submission, that's clearly an incorrect summation of the principle to be derived from those cases. The correct principle is that the plaintiff cannot increase the liability of his neighbours by engaging in a sensitive trade or occupation and requiring additional protection. And finally, on that case, the facts are a million miles from the facts of this case. Mr. Robinson, the defendant, had blasted tree stumps on his land using dynamite during the whelping season, which had caused damage to his neighbour's mink. But there was held on the evidence to be no occasion for him to fire shots during the whelping season, and there was not the slightest necessity for blasting the two stumps in question when he did. And that's at page 1039 that analysis is set out. The particular feature of that case was that the blasting of tree stumps was only required in connection with the clearance of land that was being undertaken under an assistance scheme by the Department of Agriculture. And the employees of the department who had been clearing the land had ceased their activities at the end of April, and they'd informed the defendant that they would only return after the whelping season. And nevertheless, with no good reason, Mr. Robinson took it upon himself to needlessly blast two stumps a week later, right in the middle of the whelping season, which caused damage to the mink. In our submission on the facts of that case, Mr. Robinson clearly acted wantonly to adopt the language of Baron Bramwell in Bamford and Turnley. Indeed, in the subsequent case of Rattray and Daniels, McGibbon and Robinson was categorised as a case like Hollywood Silver Fox Farm versus Emmett, in which the defendant's actions were deliberate and malicious. And that can be seen at page 1067. Just make one point about the decision of Rattray and Daniels, which was that this was not a case involving negligence at all. It was a case that was only argued in nuisance. And the defendant was held not liable in nuisance in circumstances where he had operated a caterpillar to clear his land in the whelping season, even though he had been warned of a risk to his neighbour's mink, which were damaged in the process. The defendant had proved clearly in that case that there was no malice on his part. But it so happened that he was only able to obtain the caterpillar at that time of the year. And although a separate claim in negligence had been advanced, this was rejected by the court on the basis of there was no negligence in the operation of the tractor, and that with the muffler on it when being operated, noise was reduced to a minimum for a tractor of its size. And the court in that case appeared to treat dissenting reasoning in Grandel as being authority against the plaintiff's claim that the defendant had created a nuisance. And the claim and appeal were dismissed on the basis that the defendant would not have reasonable use of his land if he were required to desist from clearing it because of the delicate and sensitive nature of his neighbour's business. And thus seen, my lords and my lady, in our submission, this is a very conventional case, applying the law of nuisance correctly, and it is not authority for the existence of a duty and care in negligence at all. Unless I can assist further.
No, thank you. That concludes your submission.
It does. Yeah.
Yes.
In your hands, Mike.
What do you want to do?
I mean, it may be, not, this isn't a bribe, but it may be that consideration of what the learned friends have said and haven't said could shorten.
Then we'll stop now. It wasn't a bribe, but it was a whatever.
What, rise the table?
And we're still all right for time, maybe. So we'll start again tomorrow at 10:30.